Tribunal. I don't know whether now is the right time to address the new evidence point, because that naturally does fall within condition 4, or would you prefer me to leave that to the end? So I'll deal with it now. There are two points really. The first is, should the new evidence be allowed in as a matter of discretion, assuming that is actually a proper application for this court as opposed to being on a remitter. The second is, even if it is permitted under Ladd and Marshall, can it be adduced to make good an error of law? And you would have seen in revenue skeleton argument reference to an Upper Tribunal case called Anglian Water, which wrestles with that case, with that point. The issue being just a bit of a chicken and egg argument, which is assuming you've got on the face of it an entirely proper reasoned decision, but the tribunal hasn't taken into account of evidence which hasn't been in front of it.
Hasn't taken account of evidence which
hasn't been in front of it.
Right.
Can you, as part of an appeal against that decision, invite the appellate body to bring in new evidence so as to make good your case on error of law, or whatever? Because an appeal from the FTT to the Upper Tribunal is only on the basis of error of law. And Anglian Water wrestles with that issue, particularly in relation to a question of fairness. And I don't know if I should take you to that now, maybe. It's just in the authorities bundle. Before addressing Ladd and Marshall, I think I should address this point first.
Yeah.
So if we just take up the authorities bundle, tab 7, and it's paragraph 101, which is on page 157 of the bundle. I just invite you to read 101.
This approach being Ladd and Marshall. This?
Yes.
Yeah.
And if I can, rather than just read the whole passage, if I can just ask you to turn over the page and just read paragraphs 105 and 106. And since the skeleton was submitted, there's been a further case which addresses the same question, and that's the case of Ketley, which is just on the next tab. Again, another Upper Tribunal decision. And if I can ask you just to turn up paragraph 55, which is on paragraph 176 of the book. And what the Upper Tribunal in that case was engaged with, as was Anglian Water, was the unfairness of a case called Caruala, where the reason why the evidence wasn't before the first instance decision maker was the revenue had it and had refused to give it to the taxpayer. So blatant unfairness. And so how do you square the circle of appeal only on error of law with what is obviously an unfair result in terms of the First Tier Tribunal not having proper evidence before it? Not because of the appellant's fault, because of the revenue. And that circle gets squared at paragraph 63. Mr. Bradley is the revenues case. I can just invite you to read that. And the extract, or Justice Carnwath's judgment, as he then was, up to the end of the first paragraph over the page. And then you will see the Upper Tribunal reaches an obiter resolution at paragraph 65 at the bottom, because it, like in Anglian Water, it finds it doesn't actually have to resolve the issue. I just invite you to read paragraph 65.
Yeah.
So you'll see that the venerable principle is explained in part. That's essentially the proposition that the First Tier Tribunal and the Special Commissioners for them, they're not simply engaged in adjudicating on a lis inter partes, as it's framed. There's actually a public interest in the tribunal trying to find the right amount of tax, subject to rules of procedural fairness. That is essentially an objective for the tribunal. And so that's why the Upper Tribunal found it was at least analogous to an assignment case, the reasons it gave. But if one looks back at the top of the test which Lord Justice Carnwath sets out, of the 4 conditions that he puts down, 3 of them are lad and marshal in any event, if you look at them. So just looking at the top of the page, secondly, the fact or evidence must have been established in the sense that it was uncontentious and objectively verifiable. Well, that's really lad and marshal condition 3. Thirdly, the appellant or his advisors must not have been responsible for the mistake. Well, that's lad and marshal 1.
It's actually higher than lad and marshal, isn't it? Lad and marshal only has to be credible. Apparently credible.
Apparently credible. No, that's quite correct. That's quite correct. Yeah. And fourthly, the mistake must have played a material, not necessarily decisive part in the IAT's reasoning. That I think that is on all fours with lad and marshal 2. So there's an extra condition which is first, which is, it starts at the beginning of the previous page. There must have been a mistake as to an existing fact, including a mistake as to the availability of evidence on a particular matter.
But that's not the test for admission. That's the test for finding an unfairness such as to be an error of law.
Correct, but there's a massive degree of overlap. Is the submission I'm making, essentially. So, in theory, you've got to go through 2 stages. If you were to follow this, whichever one you apply first, the other one overlaps to a very great degree.
So, in other words, you're saying, well, if the evidence could not support an allegation of error of law applying Lord Justice Carnwath's test, then there's no point in admitting it.
Correct, yes. Now, the oddity with the evidence which Mr. Peacock's clients wish to put in, and I entirely understand out of an abundance of caution, is Mr. Peacock, on his case, I think, doesn't need it. On my case, it's not relevant either. And it wasn't relevant on the Upper Tribunal's reasoning either, because one is not getting down into the detail of how much of the expenditure was on digging versus how much of it was shoving some plastic tubing through a pipe. What the Upper Tribunal clearly decided was a sort of higher level question of whether the expenditure was on digging or on materials or whatever. It just wasn't on the land; it was on the pipe.
So if we were to allow the appeal on condition 4, we would do what? Remit it to the Upper Tribunal to
Well,
find
I suppose
the
it depends
fact?
how you've allowed the appeal.
Right.
Because On Mr. Peacock's case, I don't think this evidence is necessary. I'm sure he's going to disagree if he wants to, but I don't think it's relevant on his case, because his argument is in relation to the land. He's not trying to split up the quantum of his claim between, say, digging and work on the pipe itself. Nor am I. Nor was the Upper Tribunal. I think the evidence was put in out of an abundance of caution of one reading of the FTT decision. But in my respectful submission, that wasn't what the FTT decided either. So we have a slightly curious case of no one actually needs or wants this evidence, but an application has been put in. And that's relevant, obviously, because it goes to both these criteria and the Lewison-Marshall criteria. Because if it wouldn't have made any difference at all, well, it shouldn't go in any event. And it's even more extreme than that, because on appeal, no one is saying this is relevant evidence either.
Well, our task is to decide whether the Upper Tribunal made an error of law.
Yeah.
And as you say, the Upper Tribunal decided that at a relatively high level. If we decide they made no error of law, that's the end of it. If we decide they did make an error of law, then we allow the appeal. So it doesn't look as though the evidence is relevant to the decision that we have to make.
I struggle to see any outcome which this court is going to make where this evidence is going to be relevant. I can certainly see if one party was still trying to sustain maybe a fallback argument, perhaps, but no fallback argument has advanced that. Oh well, point fair taken. It wasn't all on the land. Some of it was on the pipe. Let's try and apportion it somehow. But that's no part of anyone's case. Nor was it any part of anyone's case before the Upper Tribunal either. I think all that's said is on one reading of the FTT was concerned in greater detail with what practically was done vis-à-vis the pipes, and on that basis, it ought to have taken into account how much of the expenditure was on digging, how much actually working the land, and how much was on the pipes. But in my respectful submission, that isn't a proper reading of the FTT decision, and in any event, it certainly wasn't the approach to the law the Upper Tribunal take. Anyway, I obviously have to address you on this, but and it's obviously a point the Upper Tribunal has identified but not resolved on 2 occasions now. So it's potentially an issue of importance, but maybe this isn't the case to do it, where, if I'm being polite, neither party is chomping at the bit to address this issue in detail.
Yeah.
So that's the new evidence point. You'll see my submissions on the Lewison-Marshall criteria in the skeleton. Essentially, we say this evidence, they knew that if they wanted to deploy this evidence, they were quite capable of doing so beforehand. The point of what was the expenditure on was clearly identified in the pleadings and the skeleton. And secondly, we say it didn't actually make any difference to the FTT decision. So that's all I want to really say about the new evidence. So that then comes to condition 3, which is my respondent's notice point. And you will have seen at paragraph 39 of the revenue skeleton, what we've done is set out a long-worded version of paragraph 3, interposing the definition of substance from paragraph 31.
Which paragraph?
39.
39. Yeah.
So that is the legislation read longhand, as it were. Mm-hmm. The problem with the definition of substance is it slightly bootstraps, because it says substance is a substance, albeit it clarifies it could be natural or artificial. Obviously doesn't expand upon, other than the form of whether a liquid, solid or gas, doesn't really extrapolate anymore. It certainly doesn't give any indication other than natural or artificial of of whether, for example, would you consider a building a substance? You wouldn't normally say that as a matter of ordinary parlance. Obviously, what makes up the building is a substance, but you wouldn't call the building itself a substance. So we say that there are 2 points here, really. In relation to the pipes, it's not disputed that obviously the iron in the pipe is a substance. The question is the contamination caused by the iron as a substance, or is it really caused by the use of a pipe which happens to be made of iron to pump gas? And if so, is that still within the meaning of contamination by reason of substance, etc., within paragraph 3?
This argument seems to be the sort of converse of your argument on 12.4.
In what sense, my lord?
Well, you're trying to subdivide the pipe and the gas and the causation points.
It's not necessarily the obverse. I wouldn't accept that. I certainly do accept that in order to make good this point, one has to try and ascertain what the purpose of the legislation is in using this definition of substance. Because what the legislation doesn't do is say by virtue of anything else. And if one looks at, in terms of, it doesn't talk about, it just says substances. It doesn't tell you what substance is. It doesn't tell you whether, for example, a car, is that a substance? I would, or something more complicated, which is being used, actively used as a piece of machinery, is that a substance? It doesn't tell you anything about that at all. All the legislation says in paragraph 3 is that the land has to be a possibility of harm, let's say, by reason of substances present in, on, or under the land. Now, so that's all the clues the draftsman gives us. My submission is there's enough there, little as it is, and I accept that, to suggest that when one is concerned with the use of, say, a piece of infrastructure, whether or not it's chattel, whether or not it's part of the land, I don't think that really matters. When one's concerned with the use of a piece of machinery or a piece of infrastructure, any harm caused by the use of that infrastructure, for example, isn't caused by reason of substances. It's caused by reason of the use of something other than just a plain and simple substance. It's caused by, for example, the use of a car, or the use of a pipe, or the use of a building. And that's all the legislation. That's all the legislative clues one has. But I submit there's enough there in the context of what this legislation is addressing, in particular the terms such as contaminated land, etc. It is not suggesting that if you're driving a car which is capable of killing someone on a road, for example, car is a substance in or under land in one sense. But is that really what this legislation is addressing? I would submit, looking at the few clues we are given by the draftsman, that is not what this legislation is about. One has to draw a line somewhere from a point of view of rationality, because ultimately Mr. Peacock is a substance in, on, or under land, and so am I. I mean, where do you draw the line? And the point of distinction I am making...
I'm afraid if we bury your body, there are whole reasons for preventing bodies being buried anywhere, because they do degrade and cause problems. So you're quite right, you will be a substance.
However deeply you're buried, Mr. Yates.
Well, hopefully I'm not being buried.
It's the end of it.
Live another day.
Joke.
Digging.
But anyway, I appreciate this is slightly theological in a sense of trying to ascertain the nature of the Trinity or something like that. But the draftsman has used incredibly opaque language in para 3, read with para 31. And all I'm inviting you to do is just tease out, I suppose, or delineate up to what point do you say something is caused by reason of a substance, as opposed to...
What about rubbish?
What about rubbish?
Bringing rubbish onto...
Rubbish simpliciter is an offence to the senses, I would accept that. So there's nothing, you're not using the rubbish in any way, it's just rubbish.
Is rubbish a substance?
Yes, I think you would say rubbish is a substance.
Is it used, scrap metal, is that a substance?
Well, this is a point, another point of distinction. So there's a difference between something innately giving rise to harm, So you could say, given that harm is defined so weakly as an offence to the senses, maybe that's enough, as opposed to its use, its active use, and that's the distinction. That's another point of distinction I'm trying to draw. So a used car left rotting on a field, maybe that would qualify. I haven't turned my.
Well, one used car rotting in a field is not contaminated land.
Well,
but a huge plot of land with loads of car or scrap metal on, would that?
Well, just
you
say that one used car on a plot of land isn't contaminating it. Well, it could contaminate part of it.
Okay, it could be. Right.
And we have such a weak definition of contamination, i.e. offence to the senses. I can't say categorically you could rule that out. And rubbish might be a classic example. Then no one's using the rubbish in an active sense. It's just sitting there causing offence, possibly both causing offence to human senses at a very weak level, but possibly causing other environmental complications as well.
And what about the gas?
I'm not disputing. Okay, so that's the iron in the pipes.
Yeah.
The gas is clearly a substance, but again, the question is it in, on, or under land?
Well, when it's in the pipe, it's on. Given that everyone agrees that the land has to be the physical land.
Yes.
When it's going under the pipe, the reason the whole thing is contaminated is because in the pipe, it might fracture and escape onto the land. So at that stage, it's on or under the land.
Absolutely. So in a literal sense, I'm not going to try and fight reality. Obviously, the gas is under the land. But the question I'm posing in terms of this legislation is, when you're just transporting the gas through, imagine if you just had a continuous stream of lorries carrying petrol. The petrol's in, on, or under the land. It's always there. But is the legislation really capturing something which is being transited through, a commodity which is just being passed through the land?
Well, that's why it's become contaminated. I mean, there wouldn't be any need to do anything if the gas was inert and couldn't explode.
And the same must be true of most liquids.
Indeed.
It's the problem arises because you're pumping liquid through a discharge pipe and it escapes, or might escape.
But the same would also apply, given the breadth potentially of this legislation, of a lorry carrying petrol across it. Let's say you had a continuous stream of lorries, so there's always some petrol on the land. That clearly can't, respectfully...
Well, that may be right, but then the gas here, or the slurry going through a discharge pipe, is going through a piece of fixed equipment, not a moving vehicle.
Well, what if you say fixed equipment? What if it's a road? And so I'm just trying to extrapolate some examples here which can show absurdities arising. So let's say you have a road which has got potholes and cars go across it. So the road and the substance is obviously the tarmac in the road. And you say, well, I'm going to have to repair the road because otherwise it gives rise to risk of harm because potholes could cause car accidents. Is the road, are the cars going across it as well? Are they a substance in or under the land? They are in a sense. What I'm just trying to tease out again is whether when you're intentionally just transporting gas, and not just waste or just something pouring out of a pipe, but you're actively, in a controlled manner, taking it across, and it's a commodity, it's a good, is that, again, what the legislation is talking about in terms of substances in, on, or under the land?
Well, for long,
in itself,
although it's going through, it's on a journey. For the time it's on the land, it's on the land, isn't it?
In one sense, absolutely.
In what sense it isn't? In what sense is gas passing through land not on or under the land for the time it's passing through?
But in a literal sense, I'm not disputing that, my lord. All I'm advancing is a submission that where something is merely being transported, as opposed to something inherent in the land itself, it's not within the meaning of substances in, on, or under the land. That's the point. There's nothing more to it.
We have the point.
So unless my lords have any other questions.
Thank you very much, Mr. Yates. Yes, Mr. Peacock, any reply?
My lord, not on condition 3. I sense you have the scope of the debate on condition 3. Condition 4, my friend happily accepted that on in paragraph 2.2 has to be read as in relation to. And I invite you to follow the logic of that and then read those hierarchical questions in the way that I identified in So there's nothing I think I need to say about condition 4, save this, that he suggested in a couple of instances that this was a question of fact and degree, and it's not. It's a matter of satisfying the statutory requirements. It's not sufficient to say it's all a matter for the first tier to decide whether there's a sufficient nexus. The nexus required has to be found in the statutory language. As to the additional evidence, you have what we say about the sense and importance of the evidence. Well, no friend is right that on our view of the world we don't need this evidence. It only becomes material if this court said the Upper Tribunal were wrong, so their real world focus and objective focus test is wrong, but in fact the way to apply the statute is to identify exactly what this money was spent on. Was it spent on digging or was it spent on the pipes? And if you formed that view of the statute, the further evidence would be material.
Yes, but we might well remit that question if that's what we were to decide.
And then you could remit that question, so the point may well go away. Although friend is right, there is a point of principle on the Anglican water and the Ketley decisions as to circumstances in which you might admit evidence on appeal, and how that relates to the need to find an error of law before you can contemplate admitting new evidence. And I can address you on that if need be as to the matter of principle, but it seemed from a learned friend that he was suggesting that again that might be best left to another appeal.
Yeah.
So that brings me back to condition 6, and with respect to what you've heard from a learned friend, this is the real fight between the parties. It's not condition 3, it's not condition 4, it's condition 6. Maloney Friends is very clear, my clients are not entitled to relief. He was much less clear as to why that is so. He again suggested that it was never intended to apply to utilities who have mere easements, but that I'm afraid is just an assertion. He suggested that 12.4, that reference to time, must sensibly be read as the time of the expenditure. And I accept that's a possible meaning. Not necessarily the only possible meaning, but it is a possible meaning. But if that's right, you still have to ask at the time of expenditure whether the land is still in a contaminated state as a result of something you either did or omitted to do. And he meets the objection that I made that a failure to provide a complete cure would count as an omission, thereby barring relief in year 2 because of the omission in year 1, by saying, well, it's all a matter of degree, and in practice the revenue will allow cases as long as you cure within a reasonable period. And that's no doubt helpful guidance in many cases. The difficulty is that that's just not borne out by the statutory words. And this is not a relief that should be available according to the policy or the whim of the commissioners. It should be available or not available according to the statute.
Yeah.
So I hark back to the points I made in opening, which I won't repeat, that one has to look at 12.4 in the context, and whatever view one takes of at any time, you have to pay close attention to the causative need for the land to be in the contaminated state as a result of something that you have done or omitted to do, in the sense of being wholly or partly responsible for that state of affairs. Mm. And the case against me below, which I must persuade you is wrong, is that saying that we are partly responsible because we pumped the gas is unrealistic, but it's also not what the statute provides. And perhaps the last point, my learned friend's example, which appears each time we meet, the car in the car park, it's not a helpful example. It just raises too many questions. It doesn't actually help you answer this case, so I'll say no more about it. So unless there's anything else I can help you with on condition 6, those are my submissions.
Well, thank you very much, Mr. Peacock. Thank you both very much for your very economical arguments. There's obviously a lot to think about, so we will reserve our judgment. You will get a draft judgment in the usual way, which will be your opportunity to correct our spelling and grammar, but not our reasoning, or to raise new points. As you will know, the draft judgment now comes with a beefed up embargo, which means what it says. We would hope that in the light of the draft judgments you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short submissions in writing and we will make the form of order that we think appropriate. Thank you both very much.